Tracy, why don't you hold off and introducing yourself, and until you start, you can talk about that. But we're very pleased to have both Megan and Tracy here from the law firm of L.B. Thompson. Again, always do a great job of providing information on employment law and some of the new things and trends that are coming around. So without further ado, I'm going to let Megan take the stage, and then at that point in time, we'll switch over to Tracy. So thank you. Good luck, Megan. Let me know if you have any issues.
Thanks, Dan. All right, so as I said, my name is Megan Quinn, and I'm happy to have you all here today. I will be tackling the LGBTQ portion of our presentation, and then Tracy will be handling the sexual harassment portion in the second half of the hour. All right, so I have 33 slides here today. I don't think I'm going to be able to cover them all in depth, but Dan will send out our presentations afterwards so that you have those to review and can kind of go through with more detail. Before we get started on the law, I wanted to cover some of the key terms that everyone should be familiar with when discussing this topic. Sexual orientation, it refers to who you are attracted to, who you want to date, and the available sexual orientations are generally heterosexuality, homosexuality, and bisexuality. Gay is an umbrella term that refers to men and women who are attracted to members of the same sex, and lesbian refers to women who are attracted to women. Gender is different. Gender is our internal sense of whether or not we feel that we are male or female. And it's without regard necessarily to our biological sex. So gender identity is not necessarily visual. It can be if there are indications of gender that are visually available. However, it is not necessarily apparent from someone's person. Gender expression, however, is how we communicate our gender identity to the outside world. And that can be how you wear your hair, the type of clothing you wear, certain mannerisms and social interactions, and how you introduce yourself. So gender expression is external and is visible, or there are visible indications to people. Transgender is also an umbrella term that refers to anyone whose gender identity differs from the sex they were designated or assigned at birth. It's an adjective, not a noun or a verb, so you don't refer to someone as being transgendered or as a transgender. Also, the terms transgender and transsexual are not interchangeable. So a transgender man is an individual who was designated female at birth and now identifies as male. Transgender woman, the opposite, it's someone who identifies as female but was designated male at birth. I'd like to point out that the language talking about transgender people that says someone who is biologically or genetically male or female was born a man or a woman has fallen out of favor. And that's in the presentation about someone who is designated a certain gender at birth and now identifies as a different gender is the preferred language that is used. Also, transgender does not necessarily describe someone's sexual orientation. A transgender person can be straight, gay, bisexual, any of the above. So it does not, gender identity and sexual orientation are two separate topics. All right. Like I said before, transsexual is an older term that originated in the medical and psych communities. So it's not an umbrella term, and it should only be used to refer to someone if they say that that is their preferred term. Sex reassignment surgery are operations that change the body to more align with someone's gender identity. So like transsexual, sex change and sex change operation are antiquated terms that should no longer be used. Transition. This is the process in which someone changes their gender expression to the outside world to more closely align with their gender identity. It does not necessarily mean that someone undergoes sex reassignment surgery. It can be anything from just a name change to grooming habits, dressing. So there are various stages or steps that someone can take to transition, and someone is free to take some or all or none of them. The other key here is, someone who this choice to transition is seen as a choice. You can choose to transition, publicly transition or not. The law does not regard someone's gender identity or sexual orientation as a matter of choice. The last of our definitions to cover are these. So someone who is cisgender is simply someone who is not transgender. Gender nonconforming is a term that is used to refer to people whose gender expression falls between the conventional expectations of what is male and female. The key here is that not all gender nonconforming people identify as transgender, and not all transgender people identify as gender nonconforming. These two terms overlap in some cases, but they are not necessarily always the same. And then non-binary or genderqueer are terms that are used by someone who experiences their gender identity as falling outside of the categories of men and women, or male and female. All right, so now that we have those terms covered, I can move now into the law section of our presentation. So, as I'm sure every single person is aware, Title VII of the Civil Rights Act of 1964 applies to private and public sector employers and prohibits employment discrimination on the basis of several different types of protected characteristics, including sex. As is not a surprise for a law that was enacted in 1964, it does not specifically call out sexual orientation and gender identity. And if this presentation was given about 2 years ago, I would go into a bunch of different cases showing how things have been interpreted and the various splits between the courts. However, last year, everything was simplified. In 2020, in a case called Bostock v. Clayton County, Georgia, so not that far away from where I currently sit, SCOTUS, so the Supreme Court, ruled that Title VII protections extend to individuals discriminated against in the workplace based on sexual orientation or gender identity. Bostock actually involves 3 separate cases that were consolidated, but each of those cases involved an individual who was terminated after revealing that she or he were gay or transgender. Therefore, if your policies have not changed to specifically include prohibitions against sexual orientation and gender identity discrimination, you should do that as soon as possible. If you need help with that, contact Ellery Thompson. But the other thing to note is that while this case was a landmark case and very clearly said that sexual orientation and gender identity discrimination falls within prohibited sex discrimination, the Supreme Court declined to address kind of attendant legal challenges such as sex-segregated bathrooms, locker rooms, and dress codes. Therefore, we expect to see within the coming years various cases in the lower courts that deal with those issues. Recently in June, the Supreme Court declined to grant cert to a case involving a student whose school had prohibited them from using, I think, the bathroom for their gender identity. So it's up in the air when and if the Supreme Court will take up those issues, but certainly the lower courts are dealing with them. So Bostock dealt with Title VII. However, there are other laws that you should also be aware of with regard to LGBTQ issues. So the Equal Protection Clause, Section 1983 prohibits, creates cause of actions for constitutional rights and applies to public sector employers. Sexual orientation is a protected category under this, and the only question that's up in the air is the level of scrutiny that is applied. There's rational basis, there's heightened scrutiny. It doesn't really matter for our purposes and your purposes. It would be very hard for a public employer to show that there's a rational basis for allowing harassment based on sexual orientation. Therefore, what level of scrutiny is applied does not really matter in a practical application for you. As far as the Equal Protection Clause in Section 1983 with gender nonconformity and transgender status, though that type of discrimination is also prohibited. And again, it would be very difficult for a public employer to justify any kind of discrimination based on someone being transgender. So both under Title VII and Section 1983, you have potential claims if you allow, if your policies allow, or if conduct allows for discrimination or harassment based on sexual orientation or gender identity. And then just to make this clear, the ADA, which was passed in the 90s, does not consider sexual orientation or gender identity to be a disability. All right, so now that we've covered the law, we can talk a little bit about the practical issues that you might see coming up in the workplace related to these laws. So with recruitment and hiring, failing to hire a qualified candidate because of their sexual orientation or transgender status is sex discrimination. So you need to make sure that everyone who is in the position to make hiring decisions understands this, and that you have policies in place to prevent it. If it's not apparent from documents or other indications a person's preferred name, pronouns, and gender, you should make sure to ask that, figure it out during the hiring process, and use that during employment. And you wouldn't necessarily know this, but if somehow you were to learn that someone is transgender and has transitioned prior to being hiring, that status should not be revealed by the employer. That is up to the employee to reveal that to their coworkers. Now, a separate issue is if an employee chooses to transition while they are with your organization. Certainly you want to be sensitive, and it's in the employer's best interest to kind of get ahead of the topic by working with the employee on expectations, a transition plan. How do they want to address this? What are there specific steps they want to take? Is there something, you know, do they have particular concerns, or do they have certain dates, a plan or an idea of how they would like to go through the transition process. And it's very key to be both deferential to what the employee wants and keep confidentiality as much as possible regarding all the steps. So you can rope in their supervisor or appropriate people in the chain of command, but certainly try to keep it as tight as possible. Now, you want to advise or encourage employees to avoid gossip and rumors. And if you hear of any sort of rumor mill going, you need to get ahead of that because it could escalate or turn into a hostile work environment depending on what's being said. However, you are not to advise the transitioning employee to not talk about their transition. Certainly, it would be sort of hard to do that from a practical application, but also it would could be seen as discriminatory. So there's this exception that's highlighted here about creating a hostile work environment for someone who has sincerely held religious beliefs regarding transgender status. And that is more going to be based on what is being said. That's going to be a case-by-case basis. Certainly, it's within an employee's right, you know, as with any topic, to say, hey, I'd like to just stick to work. I don't want to discuss this topic with you. However, if someone becomes hostile or saying hostile things to a transitioning employee, that's where their rights end as far as sincerely held religious beliefs. If employees come to you with questions about the transitioning employee, you should refrain from talking about them. You can talk about LGBT-related policies in a general matter, but any specific questions about the transitioning employee should be directed to that employee, with the exception of kind of general admonishments to say, yes, you need to use this pronoun, you need to refer to them as their chosen name, those sorts of things. But not only should you refer for more specific questions to the transitioning employee, but you should also advise employees that they are not to ask super personal or inappropriate questions regarding sex reassignment surgery or the like. That is not appropriate for the workplace. As with all employees, you should treat the transitioning employee with dignity and respect, and it is important to express support. Silence can be interpreted as a lack of support, and your employees will notice it and will act accordingly. So it is important to provide express support for the transitioning employee and make sure that their rights are being respected. At the same time, you do want to manage expectations and encourage kind of some understanding. There are oftentimes someone will slip up with a pronoun or a name, and if it is an isolated incident that is a mistake, everyone should be encouraged to be patient and understanding that it's a process. So while you want to be supportive, you also want to encourage an atmosphere that allows, you know, some leeway as far as if someone accidentally uses a pronoun but then immediately apologizes and corrects themselves. As far as dress codes and grooming policies, a transgender employee is expected or can be expected to adhere to the dress code and grooming policy that corresponds to the gender identity. And the company should allow them to adhere to those codes and policies that go with their gender identity. It is not necessary for someone to have sex reassignment surgery or any kind of legal name change in order to start adhering to the dress codes of their gender identity. So an employee doesn't need to have certain legal steps in order to do that. If they come to you and they say that they are transitioning, you should just allow it. You should definitely make sure that all of your staff, supervisors, employees understand that they are to use the chosen name for a transgender employee and the correct pronouns. As I said earlier, there are going to be times when someone mistakenly uses the wrong pronoun. However, consistently doing that can be seen as harassment, and that can rise to the level of a hostile work environment. Therefore, if someone is consistently dead naming, which is a term that means that someone is using a transitioned employee's former name, so if there is indication that someone is consistently dead naming someone or using the wrong pronouns, you need to take corrective or disciplinary action to make sure that this conduct stops. And again, in support of the names and pronouns, it's not in quotation marks, it is their name, it is the correct pronouns, and those names and pronouns should be used in all communications. There might be some documents, some legal documents that require a legal name change, but anything that is aside from that, including ID cards, badges, email addresses, should be switched. And we're running a little bit low on time, so I'm just going to kind of speed through the rest of these. So again, someone does not need to have medical procedures or a legal name change for their transition to happen at work. So you should change all their job assignments and duties. You don't need to see proof of any particular circumstance. Bathrooms, showers, locker rooms, anything that are gender specific, this is going to depend on how your facilities are configured. But again, the general rule is that a transgender employee is allowed to use the facilities corresponding with their gender identity. An employee, if they want to, can agree to use a separate facility, but you cannot require them to do so. And even if they have agreed to use a separate facility, they are allowed to change their mind at any time. And as far as someone who objects, someone's allowed to object. They're allowed to have that belief. However, they cannot, their belief cannot interfere with your transitioned employee's rights. So that means that somebody who objects, they can choose as a religious accommodation to use a separate facility, but they cannot prevent the transitioned employee from using the facilities of their gender identity. And with that, I thank you for your time, and I'm going to hand it over to Tracy.
You should have presenter capability, Tracy.
So I clicked on the people can see your screen, but I can't see it.
Right now it says handling allegations of sexual harassment and misconduct. So your first slide is on the screen right now.
So how do I see that? Do you have any idea?
So I think you should be good. It's your screen right now.
Okay, I can't see my screen. I think it's showing underneath the, like I can see my face, my big mug on the screen, but I can't see my presentation.
Well, I think, let's see. Go ahead and try and move your presentation. Go to the next slide.
Dan, I can't even see my presentation to move it.
Oh, okay. Let's see. Hold on one second.
I'm not, unless I click out of the webinar. Oh, wait, hold on. I think I might have got it. Maybe, okay, let me see. Okay, I think I got it.
Okay, yep, you're there.
I can't see what anybody else is doing, including myself and my camera. So can you hear me?
We can hear you.
Yeah.
All
We
right.
can see you.
Just speak up if something goes awry, because otherwise I'm just going to be moving along. So welcome, friends. It's good to see you virtually, at least your names anyway. I hope everyone's doing well and has had a safe and healthy past year, and hopefully we'll be back in person doing these next year. But for those of you that don't know me, my name is Tracy Glanton. I'm an attorney here at LRB Thompson as well. And a good portion of my practice is public sector. So I would say probably 90% of my work is helping you guys. I work a lot through the GRMA helpline as well, fielding questions and helping those members through various personnel issues. So, so the second part of the presentation, we're going to focus on just kind of sexual harassment, and I'm going to touch on just some key points in terms of investigating a harassment complaint. If you guys have had the same experience as us over the last couple of years, there's definitely been an uptick in harassment complaints, including sexual harassment. I think that's partially because of the attention that the MeToo movement has gotten over the last couple of years, bringing to light issues in the workplace, sexual harassment, helping people recognize what harassment actually is, encouraging people to come forward when they're experiencing harassment at work. And so I know that for those of you that are in HR, I know that you know, it takes a good chunk of your time when you do get a complaint, when you are the investigator. So I know some of you have been through the process before, and so this will be nothing new to you, but hopefully we'll just kind of go over a couple key points, you know, that have come out of the MeToo movement, as well as covering some of the just key points for investigation. So I know many of you already have policies in place. Your harassment policies have specific requirements for training, sometimes annual training or biannual training. But since the MeToo movement, there's a couple situations here on the slide that just show how, you know, the federal courts, state governments are moving towards requiring harassment policies and training, particularly in the public workplace. I know there's a number of states, California being one of them, that have mandatory harassment training requirements, and I think that's the direction, you know, that we may see in the future. You know, as you can see here, there's already been some direction from, you know, our Chief Justice of the Georgia Supreme Court, as well as our governor, you know, imposing certain requirements with sexual harassment policies and reporting procedures to encourage people to come forward so that the employers can address those situations. I will mention too that I know at least some of our clients also, in addition to kind of the annual or biannual training that you might do, I know that some of our clients also require all new hires to participate in some form of harassment training, whether it's a recorded training that they do for their entire staff, or if you do online training. I know that's also made available to new hires so that you can show that you are kind of training from day one going forward. So proper reaction to MeToo. You guys all fall within this category, right? That's why you're training with us today. But the proper reaction to MeToo, I think, you know, on the one hand, there are people who You automatically believe the accuser, and on the other hand, you automatically believe the victim. But as employers, we have to take a different approach, right? So proper reaction, first of all, is to make sure that, number one, you've got updated anti-harassment policies in place, and then conducting training with greater emphasis on sexual harassment. Sexual harassment is a little bit different than general harassment. And generally, your policies are going to cover both, but you want to make sure that, number one, your harassment policy is not limited solely to sexual harassment, but you want to make sure that it also touches specifically on some of the distinguishing characteristics of sexual harassment from other types of harassment, like racial harassment, disability harassment, and things like that. Taking all complaints of sexual harassment or misconduct seriously, regardless of whether they're stale or untimely. So one of the things that came out of the MeToo movement is many allegations of misconduct that occurred years in the past. And what the MeToo movement has kind of encouraged is not to just disregard those complaints. There's a lot of reasons why someone may not come forward with a complaint at the time that it's happening, retaliation being one of the primary reasons. But I think oftentimes when you actually do start to look into the situation, you realize that it's not just an isolated incident from years ago, but that the conduct has continued through the years. And so don't just disregard a harassment complaint because it happened years ago. It might hinder your investigation in terms of the type of evidence and statements that you may be able to get, but regardless, make sure that all of those are taken seriously and investigated. Taking disciplinary and or other corrective or remedial measures reasonably designed to address any sustained complaints of sexual harassment or misconduct. So as we'll talk about in a couple slides from now, one of the primary objectives of the employer in terms of defending against a harassment complaint is to make sure that you are taking corrective measures to eliminate harassment from the workplace. And it may run the gamut from something as simple as a reminder of the policy versus separation of employment. And then document any decision which may at first blush appear to be overly lenient. For example, if you decide to retain the alleged harasser, there might be a lot of mitigating factors that we'll talk about shortly that may factor into the decision that, if there was a single incident, but it was serious and it was years ago, and there's been some mitigation since then. If you're just looking at the incident itself, you might wonder why that person is still employed. So you want to make sure that you document any factors that may play into your decision if you're not going to separate that individual. So the improper reaction of MeToo, this is not any of you, but managers and supervisors becoming defensive, right? It's like someone accuses you of a harassment. What are you going to do? You're going to avoid the individual, right? I mean, you're probably offended that you're being accused, but then you also don't want to put yourself in a situation that may garner another harassment complaint or a retaliation complaint. So what not to do for managers and supervisors in particular is to become defensive and then refuse to do your job, i.e. manage the individual, by minimizing contact with them, leaving them out. All of those things can potentially result in a retaliation claim. Another thing that's come out of the MeToo movement is, kind of this idea of, swift reaction, right? I mean, I remember one day Matt Lauer was on the Today Show and the next day he was gone. And, I think that tends to be the reaction of many employers. They want to separate themselves from anything that's going to give the organization bad publicity. So it's just easier to enter into a separation agreement, pay the person some money, separate, from that individual and move on. However, there's some problems that could arise if you do that as a public employer, and that is those individuals, the accused, have due process rights. And so particularly for those of you who are not employed at will and do have actual constitutional property rights and are subject to due process, the employer has the burden of establishing and proving the reason for discipline, including termination. So unless you take the time to actually investigate the complaint and discover evidence that supports your decision, you're going to violate that individual's due process rights. So while it might be the preferred way of reacting for a private employer, to just separate and deal with the fallout, as a public employer, you've got to treat the person as kind of innocent until proven guilty, right? And so you've got to take the time. You might get pushback from the community, you know, why is this person still employed? You know, and the reaction has to be, you know, we take all complaints seriously. We're investigating the complaint, and we'll take appropriate action once we determine whether or not the complaint is substantiated. And what happens if you retain an employee, right? I mean, there might be many reasons why you would retain an employee, but some concerns that would arise. You know, I've had a number of clients say, look, you know, I sustained this complaint of harassment. Do we need to get rid of the person? And if we retain them, you know, can't we be liable for negligent retention? And all of that just depends on the circumstance, right? So depending on, you know, how long ago was the incident? How serious was it? Has the person, you know, been to counseling? Were there certain things going on in that person's life at the time that this happened, and those are no longer a consideration? You know, there might be a lot of reasons why you would retain the accused employee that wouldn't necessarily lead to a claim of negligent retention. You know, but on the other hand, there could be a concern that once you're on notice, that somebody has the propensity to engage in harassing behavior, and you continue to let the employee remain in the workplace, you know, that is a problem unless you make sure that the person's rehabilitated and you're putting in place a training, counseling, whatever it takes to make sure that that person is rehabilitated and that you're making every effort to prevent further misconduct. So these are just some of the mitigating factors that could justify retaining an employee. You know, again, has the person grown from the incident? Have they taken responsibility? Have they been to counseling? You know, maybe the person was going through a difficult time in their personal life when the harassment occurred, or the relationship occurred, that may factor into why the person acted the way that they did. So take those into consideration when making your decision about whether or not to retain an employee, and kind of balance that with the severity, the time lapse, all of those things. You know, at the end of the day, you're going to have to defend your retention decision if you're ever questioned about it. So make sure that you go through that thought process and that it's documented, you know, what those mitigating factors are. So I know some of you, or probably most of you, find yourselves in a position of having to investigate a harassment complaint. And so I just wanted to highlight just a couple tips that you should be incorporated into your investigations. And I think to start, I just wanted to reiterate the defenses to a harassment claim, right? I mean, so we always focus on make sure you have a policy, make sure you have a reporting procedure, make sure you do investigation. Why are you doing that? Do you know? Okay. And so you're doing it because that is the way that your organization defends against a harassment claim. Okay. So if there's no tangible employment action, you have a defense as long as you do a couple things that we're going to talk about. But I will say that if the harassment results in an adverse action, for example, and again, this can only be by a supervisor or somebody who has authority to take an employment action. But if a supervisor conditions a promotion, for example, on acquiescence to some type of, sexual conduct, and the person refuses and the person doesn't get promoted as a result, the city or the county has no defense to a claim like that. I mean, the employer is strictly liable. Fortunately, we don't have many situations like that. And so other ways to defend against a claim, even a supervisor who's harassing, an employee in the workplace, there still is a defense. Okay, but this is what you're going to have to show. You're going to have to show that you exercised reasonable care to prevent and promptly correct the harassing behavior. So the way that we do this is we point to our policy. We show that, we've identified the conduct that is not permissible. We show that we have a reporting procedure, that we encourage reporting, and that we will not tolerate retaliation for individuals who come forward and make a complaint or participate in an investigation of a complaint. And then what we show is we investigate complaints that come to our attention, and if the complaints are sustained, we take corrective action, and that the corrective action is appropriate. And, we have taken every effort possible to eliminate the harassment from the workplace. It's one thing to have a policy, but if you don't enforce your policy, you might as well not have one. So that's number one, why you have a policy, why you investigate, and why you take appropriate corrective action so that you can meet the requirements of the first defense. The second element of the defense, I should say, is that the employee unreasonably failed to take advantage of any preventive or corrective opportunities provided by the employer or to otherwise avoid harm. So if the employee just sits back and doesn't say anything and just continues to subject themselves to the harassment, notwithstanding the fact that the city or the county has a harassment policy with reporting procedures, unless they can explain why they didn't come forward and make a complaint, if you can show that they didn't take advantage of your reporting procedures, then you can defend against the harassment claim. The problem is if you, for example, and I've seen this before, you might have the employee that says, why would I bother making a complaint when everybody else, and I've identified 5 other complaints where people have made complaints about a certain individual, for example, and nothing was done. Or I've watched people make complaints and then next thing you know, they're no longer employed. So if they're able to show evidence of retaliation as well, that might be a reason, an acceptable reason why someone might not bring a complaint forward. So again, going back to that, if you don't have a policy, if you don't enforce it, then an employee can probably reasonably show that it was reasonable for them to not report. So, all right. So preparing for the investigation, I think, is probably the most important part of the investigation. Because if you don't prepare, you're not going to get the information that you need to discover what actually happened. So first things first, read the complaint, figure out, who might be potential witnesses. And you have to select the appropriate investigator. So consider potential conflicts of interest, actual or perceived, right? So if there can be a perception that somebody, if the, investigator has, a certain bias against an individual, or there's this perception of favoritism, or they have a good relationship with somebody that they're investigating, there might be a perceived or actual conflict of interest. So you want to make sure that that's not present, and if there is any question, find somebody else to do the investigation. consider the need to utilize an investigator from an outside agency. Now, you don't have to do this all the time, but there are definitely circumstances that warrant bringing in someone from the outside, especially if you have kind of higher level supervisors, that are either, the subject of the complaint, or maybe witnesses in the complaint, or there's some other reason that you really need somebody who's going to come in fresh with no perceived conflict, no favoritism, no biases to investigate the complaint, to show that it brings neutrality to the process. And also, as many of you know, you wear lots of different hats. So these investigations can take a significant amount of time, depending on what the allegations are. And sometimes these complaints can take months. So, make sure that whoever you identify as the investigator has the amount of time to be able to investigate the complaint. Balance the need for a prompt investigation against the need for adequate preparation. And what this means is that if you are not prepared, or if you go ahead and investigate the complaint because you want to meet that promptness element, but you have just done a shoddy investigation, that is not going to bode well for you in trying to defend against a harassment claim. So you can justify a short delay, or however long a delay you need to get prepared, as long as you're actually working towards starting the investigation, starting the interviews. You might need to gather certain kinds of evidence. It might take you a while to find the right investigator. You might need to get approval from your council or your commission if you do have to hire an outside investigator. So there's lots of reasons why it might be delayed. And if that happens, I highly recommend that you keep in communication with the complainant, because the last thing that a complainant wants to feel is that their complaint is not being taken seriously. So if there's going to be a delay, let them know. Also, let the respondent know, the person who is the alleged harasser, because a lot of times that person is going to be on administrative leave. They're going to be anxious, because now they're accused of misconduct. When are they going to be able to come back to work? Are they going to lose their job? How long is this going to take? So keep in communication with the individuals involved, the subject or the complainant and the respondent, and let them know that you're moving forward with the investigation. If there's a delay, then be sure to communicate that to them as well. Consider the need for interim remedial measures. And the reason why you want to do this is you want to make sure, number one, that there's no more harassment while the complaint's being investigated, and you want to make sure that there's no retaliation. So you might have to make a couple adjustments to your personnel in order to make sure that those things don't happen. So you might have to, people are working on the same shift or in the same location, you might have to make a couple adjustments to ensure that separation. A lot of it's going to depend on what the allegations are as well. Administrative leave of absence. Oftentimes this is probably the best thing to do, just to avoid what we just talked about, but avoid any reference to it being a suspension. And I understand some of you have policies that kind of refer to the disciplinary, administrative leave of absence procedures, for, in your harassment policy. And, certainly, you can do that, but I would just emphasize that it's a non-disciplinary administrative leave of absence. And, in absent unusual circumstances, that should be, with pay and benefits while the complaint is being investigated, to avoid any kind of adverse action. If you're not going to separate the individuals, put someone in place to monitor, to make sure that there is no more harassment. If you have to do that, I'd probably suggest making a different kind of adjustment. And then try to avoid inconveniencing the complainant, because again, you don't want there to be an appearance of retaliation. So, unless the person says, look, I just want to take a little bit of leave, I want to get my mind right, while you're investigating the complaint, that's fine. But if the complainant does not request leave, err on the side of inconveniencing the respondent. And you can explain, look, this is for your best interest. We'll get to the bottom of this, but it's in your best interest. You want to be protected from any kind of additional allegations of harassment and retaliation. As part of your prep, make sure that you review your relevant policies, procedures, SOPs, regs, guidelines, anything that is going to kind of guide your investigation. Know what you're investigating. Identify the witnesses to be interviewed. Now, this may change and evolve as you get into your investigation, but kind of identify who you think is going to be a relevant witness and determine the ideal order to do those interviews. Gather any type of documents or evidence, emails, voicemails, video surveillance, body cams, whatever may help assist you in discovering the truth. Prepare witness outlines. I usually do that for depots and interviews. I have broad topics. If there's, a particular question that I want to ask a certain way, I'll actually write that out. Otherwise, I might just have some bullet points to make sure that I'm touching on the information that I need. So, use your outline as a guide. Don't be inflexible. Make sure that you ask follow-up questions. Leave no stone unturned. Remember that every investigation is potential evidence. So make sure that you're doing a thorough investigation, that you're, taking notes that you can actually, read later. You might have to rewrite them and, or type them, if you have to refer to them later, but make it as professional as you can. Witness interviews, couple key points. I rarely, if ever, interview people together. A lot of times they want to get in a room and they all want to talk about it, and next thing, nobody knows what exactly they remember, right? Are they remembering what someone else is remembering? Is a recollection getting skewed, influenced? So I always recommend interviewing individuals separately. Make a record of each interview. I know some people prefer recording, and that's fine. You might have a witness there who's taking notes. You might be taking notes yourself, but make sure that each record or each interview is recorded. And please, please, please put the date on your notes and on your report. Explain the necessity of cooperating with the investigation. If they don't cooperate, guess what? Statements of other people are going to trump. And if you don't want to cooperate and you're the complainant, then you're going to be limited in your ability to investigate the complaint. Don't promise confidentiality. Let them know that you will keep the investigation as confidential as possible during the investigation, but because of sunshine laws, open records, all of that becomes public once the investigation is over. On the other hand, I do recommend instructing the witness not to discuss the investigation in order to maintain the integrity of the investigation while it's ongoing. And then always just explain that retaliation is prohibited. And then your report. Always write a report. What are your factual findings? Were your witnesses credible? Credibility doesn't always relate to truthfulness, right? If it's he said, she said, you've got to make a determination about what happened, even though you might not be able to prove it one way or the other. Maybe people have different recollection of events based on what they say and based on any type of tangible evidence, what seems to be closest to the truth. So make those determinations in your investigation. Do you know what happened? What's the story? Is there anything out there that, are there any holes in your investigation? If so, make sure that you fill those holes in before you close up the investigation. And then prepare a report, make factual findings, focus on your policies. Don't make legal conclusions like this is a violation of Title VII. Well, you're not a lawyer. And even lawyers who are doing the investigation, we recommend do not make those types of conclusions. Focus on your policies. Let the judges and let the juries determine whether or not there's a violation of the law. But if you actually make those determinations, while it's not binding per se. You know, if the city or the county has to defend against the claim later on, you know, and you get in front of a jury and it's like, oh, well, your HR manager said that this was a violation of the ADEA. Well, that's going to be pretty persuasive to a jury, you know, even though that they probably shouldn't take that into consideration. So focus on your policies. And then unless specifically requested, try not to make recommendations. Let the decision maker make the recommendation. You be the fact finder, unless it's within the scope of your authority to do that. Because again, you might make recommendations that for whatever reason, the decision maker might go a different direction. And it just provides a little bit of flexibility for that. This is the last slide, so if you can hang with me for 30 seconds. And then the outcome, right? So if you have reasonable evidence that the alleged action did occur and you are the decision maker, let's say, assess the severity of the action. You know, is it a single incident? Is it severe? Is it, you know, conduct over a period of time? So assess the severity, ensure that discipline is consistent with past practice. If you make different decisions based on similar conduct, make sure that you can articulate why you made that different decision. Follow your policies and procedures, and then document any actions that are taken so that you can show that you took appropriate corrective action based on the information that was available to you. And finally, if you've got evidence that the alleged action did not occur, so you're not going to substantiate the complaint, explain that to the complainant and the respondent. Reiterate the employer's policy. I always say, look, even if you didn't find a violation, remind the accused of the policy. I know you didn't, you know, it's not, this complaint's not substantiated, but as a reminder, you know, city or county policy says blah, blah, blah. And then finally, remind the respondent that retaliation is prohibited. And usually, I mean, I think a lot of you use forms anyway that say, you know, how the investigation was resolved, and as a reminder, there's no retaliation. So that's the, those are the highlights. This is probably a half-day presentation at least to get into all the details, but hopefully you all found this helpful. And as you go forward, just a quick reminder, you know, of you know, why these investigations are important and why they need to be thorough. All right.
Thank you so much, Tracy, and thank you, Megan, for your presentations. Great job, both of you. I'm sure if you were anywhere near, your ears would be bleeding because of the loud applause by all the people online. Anyhow, with that being said, there is time, a little bit of time for questions. Does anybody have any questions they'd like to propose? As we talked about before, if you can, just type those in or raise your hand and I'll try and call you. Let me see if I can find anybody to talk to. Let's see. Well, not getting any luck. So with that said, again, I would just say you did, here's one. What happens when you have a situation, and that's pretty, can you expand on that? What the situation would be? Any of you feel like answering what happens when you have a situation? Here, when someone doesn't want to file a complaint since prior action was not taken. It's a good question.
So if somebody brings to your attention that they have a complaint, but they don't want to come forward because they don't think that anything is going to be done, because I guess in their mind nothing's happened before, I would encourage them to bring the complaint forward. I mean, as you looked at, as we went over those defenses, I mean, that's a pretty, it's a pretty high standard for the employee to be able to show that that it was unreasonable for them to follow the process. So I think you would have to have, complaints of a similar nature and show that, the employer did nothing or, didn't take appropriate action to correct the behavior and it continued. So I would encourage someone to, at least bring the complaint forward. Hopefully you have a policy that says that, that they're supposed to report any violations of policy. So I would point to that as well. And I mean, at the end of the day, you might have an obligation to bring the complaint forward. And we talk about that in some of our other training. What if somebody asks you to keep something confidential? Well, under your policies, you can't keep that information confidential. If you know about it, you have to report it. And so I always say, if somebody comes to you and asks you to keep it confidential, you have to say, look, that under the policy, I've got an obligation to report this. And so I can't promise confidentiality, and let the person decide if they want to, proceed to tell you what's going on.
So, for example, and this is a question based on that, somebody comes to you and say, I just want to say, I don't want to report anything, but this is happening to me. Somebody's harassing me for whatever reason, and you do nothing, then ultimately, if there's an issue, potentially the blame will go on you, correct?
It can, absolutely. Yeah, I mean, if it comes to light that you knew about it, especially if you're a supervisor, or you're in a position where you're obligated to take action, yeah, I mean, if it comes to light that you knew about it and you did nothing, that's problematic.
So, Megan, here's a question for you. If we have gender-specific restrooms, do we need to make modifications before the transitioning employee's first day of work?
No. You just need to allow them to use the gender-specific restroom of their gender identity.
Very good. Any other questions? Very good questions from the group. Here's what we have. What do we do if a complainant was made or a complaint was made about a general harassment and nothing was done? Then the complainant resigns but changes their mind and files another complaint. Do we accept the resignation without consideration of the complaint?
I mean, I think you can accept the resignation, certainly, but I also think you have an obligation to investigate the complaint.
And again, if those situations, that's something, again, if they're a GRMA member, they probably calling the helpline for that might be a good thing to work out the specifics. If they're an IRMA member, then I would say that would be a good thing to work out the specifics in regards to it. So again, that service is available for all IRMA and GRMA members. ACCG property and liability, GMA property and liability. You have a helpline on both sides, different law firms, but they will definitely assist you. And with so I would specifically, when you have questions like that come up, I would pick up the phone and give them a call, and they'll be able to hold your hand through those particular situations. Anyone else? Great questions. Here, if we require forms of ID, driver's license and social security numbers, when noting name change for E-Verify, will that still apply without issue of those that want to use a new name?
Well, legal documents are legal documents, and someone needs to go through the proper channels to change those legal documents. So, if you need to verify somebody and all they have is a driver's license that has, the gender that they do not identify with, you have to use those. But that in a social setting and within the employment setting, you should use their preferred name and pronouns.
Very good. Excellent question. Anybody else? Great webinar. The LGBTQ session was very informative. Good comment there. I'm going to say you guys did a great job, and thank you so much. I'll applaud. You guys for you. Thank you so much. We will be sending out a recording and the webinar web presentations after the second version of this. But thank you both so much, Tracy and Megan. Really appreciate it. I'll see you in a week or so on the next one. With that being said, everyone have a great rest of the day. We will talk later.
Bye. Thank you.
Thank you.